you're here for, hopefully in the right place, the succession presentation. As a little bit of an intro, and I'm going to talk more about this after we do our bio introduction. Mona Nia, who's here, present today, originally asked me to see if we could put together some kind of crossover presentation involving probate. We tossed around some ideas, and it seemed very natural to have a crossover with business entities, not only because I was handling a few cases where business entity problems were arising, but they seem to be very common, and it seemed like a good crossover issue to address.
Can you please speak up?
Oh, yes.
You tended to fall off in the middle of the sentence.
I'm sorry. I'll bring the microphone much closer so you can hear me. So it seemed very natural for us to have a presentation with a crossover to business entities and the problems that you might see, not only in planning, but also kind of litigation, what kind of tools you might be able to employ to resolve issues that come up after the death of an owner. So hence the name of the presentation. Also, I don't know if you've seen the HBO series Succession, but there are a lot of different kind of popular shows and movies that involve like death of business owners. So it was just an interesting idea. Introductions. First, we're going to talk about Brandon. Brandon's a certified specialist in estate planning and is a partner of Brother Smith LLP. In addition to estate planning, he has significant experience in taxation, trust administration, and probate procedures. He develops business succession plans, executes estate freezes. You're going to have to tell me what those are. I'm not sure what those are myself. And address a variety of income transfer and property tax issues. He can prepare sophisticated estate plans, incorporating advanced techniques such as intentional trust, charitable trust, and qualified personal residence trust. He got his bachelor's degree, a law degree, and LLM at University of Miami.
Okay.
Are you going to go to the college football game next year? I hope everybody goes to Memorial Stadium next year. Their Cal is hosting University of Miami. It's just been announced. As such, he's also licensed to practice in Florida. Fun fact, he and his wife were both born on holidays. He was born on Christmas and his wife on St. Patrick's Day. Do you get double presents for Christmas?
No. As a Jewish kid born on Christmas, it's just an opportunity to overlook my birthday.
Not worth it.
Yeah.
Do you have to prefer corned beef and soda bread?
Yeah, I used to. Now that I have 2 young children, my wife reminds me that it's no longer my birthday, it's their Christmas. So it's just completely forgotten.
I'm sad to hear that. You should celebrate in July.
I did that in grade school because everyone, was out in the Christmas break, so we would do it just before summer break.
Next, I'll talk about Ryan. He's a certified specialist in tax and a partner at McKenna, Brink, Signorotti. I just checked the State Bar website. He's one of only 14 certified tax specialists in Contra Costa County, whereas next door, the family law presentation, which involves discussion about tequila, if you need to move over to that. They have something like 80 or 90, from what I recall. So he's a rare breed here in the county. Go to him with tax issues. He received both his law degree and LLM in tax from Golden Gate University Law School. His practice focuses on estate planning, tax planning, multi-generational wealth transfer planning, business succession, tax controversies, trust administration, probate, and corporate reorganizations. Fun fact for Ryan is that prior to becoming an attorney, he served for 6 years on active duty in the U.S. Air Force, including the most recent time was at Travis, correct? Yeah. Thank you for your service. Welcome. And I'm Mike Beuselinck. I'll start with my fun fact. Following on Brandon's theme of holiday birthdays, I was born on George Washington's birthday, February 22nd. But I get hosed every year because President's Day is only celebrated sometime between the 15th and 21st, so I always don't get it on my birthday. I'm a solo practitioner. While I'm not a certified specialist like my colleagues here, I specialize primarily in real estate. In addition to handling real estate transactions, both large and small, I have extensive experience as an advisor and advocate in real estate litigation, particularly involving co-ownership issues and title disputes mostly. So it often requires me to address issues about trust and estates, both planning and administration, tax and business entities. And often in all the I would say very much often in all my real estate matters, there's some kind of business entity issue involved. But we'll talk about that during the presentation. And that's a great tie-in. So again, this was intended as a crossover presentation. Can I just get a show of hands? Like, who is I know some of the people here are probate. Who's mostly probate? Trust administration? Okay, and then business people? Okay, and anything else?
Real estate.
Real estate, okay, there we go. All right, there's some good stuff there too. So there will be something for everybody. The goal is not to overload you with statutes, cases. The goal is to provide tools for issue spotting and knowing what kind of problems can arise both in planning and administration. So if you're going outside the sphere, what do you know, what your specialty is, at least you can spot those issues and research them. Go to the Rudder Guide. I mean, this is what I do. Rudder Guide, pass-through entities and corporations. That's where you're going to find like most of your tools for complaints, petitions, how to address some of the business issues. And for you business and real estate people, this is going to give you an insight into how you can address these issues on the front end through planning, and how do you avoid those issues and understand what's going on kind of in the business context. So that said, let's see, let's take a look, and that's me, sorry. With that in mind, let's take a look at our agenda. First, I'm going to go over quickly some of the basic entity characteristics for businesses, pros and cons of using different entities, some big issues to look out for, just so everybody's up to speed on kind of the features and structures of these entities, what to be looking out for when you're doing planning or post-mortem issues come up. Then we're going to move on to succession planning. Brandon's going to kind of take the lead in discussing planning issues that could arise. As you could gather from both of their bios, these two are experts in the field of that. So they're going to cover a variety of issues related to planning for death of an owner, taxation, administration issues. And then finally, I think we'll have enough time for some litigation and administration hypotheticals. We've set up a few hypothetical situations you might encounter commonly in probate or business. And we'll identify some tools that you can use to address post-mortem issues arising in businesses. So, and finally, if we have time left, we can do Q&A. I'm not going to stop you from asking questions as we go along, just in case you need some clarification, but we have a full section at the end where we can take your questions. That said, moving on, let's go through some of the forms of business ownership and entity characteristics. Again, very basic recitation. I'm not an entities expert, but there are things you have to understand about these entities to make sure they function well. If you went to the presentation this morning about kind of a checkup for business entities, that probably was a good primer in how you set up an entity and what kind of documents have to be in order and adhering to all the formalities. So I'm just going to talk about the entity characteristics and why you would use one over the other in particular situations. So let's start out with sole proprietorship. This is probably the simplest entity. Single owner, single management, probably least expensive to set up for conducting business. There's nothing wrong with it, really. If you talk to my colleagues, maybe there's some better choices, such as maybe an S corp. You can save some money on taxes, self-employment taxes and so forth. So, but there's really no problem in someone owning something through a sole proprietorship. They're filing the same income tax returns. It's a Schedule C on the 1040 return. State income goes on the annual Form 540. So you don't need separate tax returns. You may have to register for city taxes based on revenue, depending on the city, but very simple tax reporting and payment. No limited liability. I mean, that can be an issue for a lot of people. I get a lot of calls. Somebody wants to own a property and they say, well, I want to form an LLC. Okay, how many members? Is it just you? Okay, well, what exactly are you buying? Well, I don't want to get sued. I want to protect my assets. Okay, fine. But, there is something called alter ego liability. Why don't you get some really good insurance coverage, because you don't want to have to pay your own defense bills, if and when you get sued. So I usually steer people toward, just making sure they have good insurance coverage rather than focusing on, creating these limited liability structures, especially if they're a sole proprietor. But if they wanted to use a different trade name, different business name, it's as simple as going to the county clerk and filing the FBN, DBA registration, and publicizing that. So very simple structure, very useful. Moving on, general partnership. Let's get a little more complicated. This is kind of a default way of doing business for at least two owners, but generally disfavored because of the open-ended liability aspect. I don't see them very much, honestly. Sometimes you see joint ventures between owners of real property or some kind of project or a particular job, but I don't see this very often, honestly. Management is all owners. You do have pass-through tax reporting. In theory, you could file a income tax return, issue K-1s to partners. One interesting benefit of this is you're not subject to the $800 minimum franchise tax fee. So, if you want to register it, fine. If you want to file a tax return, fine. No $800 minimum. You can file a statement of partnership authority with the Secretary of State. Interesting in litigation, if you try to look up these statements, you can't even find them through the Secretary of State's website. So people register these things, have a statement, tax, partnership authority. It's not searchable, so that's kind of interesting. But there's, as I said before, there's jointly several liability for all the partnership obligations. So it's very important to have a partnership agreement. And I'm going to talk about this a little bit in the context of tenancy and common ownership of properties later. But with that liability issue, you really want to be clear and have a contract, some kind of written agreement between the partners about how they're allocating liabilities, what kind of authorities they have. Counseling your client, you don't want that to be open-ended. So I would highly recommend that, looking out for that. Moving on, limited partnership. This, you have a structure where there's a general partner with effectively personal liability. There are exceptions to these rules, but generally personal liability for the general partner is typically the manager, whereas the limited partners are not really active, typically not active participants in the management of the partnership. Pass-through taxation, you have partnership tax returns, 1065, 565. forms, issuing K1s. There's no self-employment, going back to the, S corp kind of issue. There's no self-employment tax, or partner income unless they're actively participating in management. The way you form this is by filing a certificate of limited partnership or an application to register for an LLP with the Secretary of State. And the core operating document is a partnership agreement. While you would look at the general partnership, and it doesn't necessarily require a written partnership agreement, the limited partnership, you definitely need, again, a written agreement to kind of establish those relationships and make sure to establish limited liability for the limited partners. You commonly see, at least I see these a lot in kind of investment partnerships, venture capital. I see them less often now because people are using LLCs for these kinds of investments. Limited liability company, which I'll talk about in a minute, has the taxation and filing and organizational aspects that are beneficial, but it also has limited liability, and then the manager isn't personally on the hook for liabilities of the LLC. So I often see LLCs, but I will say for the real estate attorney firm, you really haven't lived, and experienced limited partnerships until you've resolved title to a property from a recorded limited partnership agreement from the 1960s. It's only like 3 pages long. So like negotiating a buyout, clearing title, dealing with title companies. So you see these things once in a while come up, but they're just relics in a certain way.
Sorry, I'll just say that for the estate planning folks, FLPs, family limited partnerships, which were standard for a very long time, definitely a big push, and I'm part of them, pushing people to family limited liability companies. Because I just think they're easier to operate than FLPs, especially you see some of these FLPs that are older, and they have different classes of limited partnership interests with different rights, preferences. It gets really confusing, especially for appraisal, which we'll talk about later. So I think LLCs are definitely becoming popular, even in the estate planning context.
You want to talk about LLCs, or? Yeah, I can talk about it.
I'll have thoughts.
Okay, you'll have thoughts on it. As I said, this is generally the entity of choice for new businesses. You can even have single-purpose entities for real estate holdings or particular investments, particular projects. It doesn't necessarily have to be an open-ended operating company where it's LLC owns 20 properties. You can have a single-purpose entity for each. Management, you can designate managers, or you can have member management, and there are different kind of aspects of that, why you would choose one over the other. Pass-through taxation, same as a limited partnership. Limited liability for members, also the same as a limited partnership. But as I said, manager isn't personally liable for the LLC debts and obligations, and I think that's why you see these more often. Simply requires filing articles of organization with the Secretary of State form. You got to pay the $800 minimum franchise tax, and you need an operating agreement. Very important. I'm going to talk about kind of the formalities in the next. Are you having anything to add on the LLCs? No?
I personally like LLCs more for my clients, especially in the estate planning context, just because they are very, very flexible. They're tax as partnerships. You can have them taxed as a C Corp. There is an election that's available that's really unique. People usually want LLCs for that pass-through taxation. And with partnership taxation, the flexibility is great because as you'll see when we talk about S Corps, distributions that are coming out of an LLC, you can specially allocate them. So when you talk about multiple generations, it's really easy to say, we want to keep income to generation A, but we want on paper generation B to have some ownership in this. So this is why I think they've become so popular in the estate planning.
And speaking of corporations, we'll move on to that. More complicated. I'm just going to say for you estate planners, there are more formalities. It costs more. Just think about it as we're increasing the complexity as we go through these entities. So, and you can have different types of corporations, obviously, kind of nonprofits or tax exempt, professional corporations, which we all see as attorneys all the time. By the way, just I don't know if you all have seen this or know this, but I see a lot of large firms. It looks like they're a limited liability partnership, but in fact, each of the partners has their own S corp. So each of the partners is an S corp. It's not the individual partner, and I think they do that to maintain kind of self-employment. They get the tax benefits of the S corp, meanwhile having the overall structure of the limited liability partnership. I don't know if you've seen that. So, and then you can have general stock and closed corporations. They're all different kind of features for these, and each of these entities has a different type of filing for the Secretary of State. So you can't just form a professional corporation by using a general stock corporation. Articles of incorporation filing has its own special form. So management, effectively you have a board of directors that's elected by the shareholders, and officers that are appointed by the board. You can have different forms of ownership, share classes, ownership restrictions, just single shareholder ownership, not a problem there. As far as taxation is concerned, as I said, more complex than pass-through taxation. You're taxed on accumulated earnings, so they always talk about double taxation. You're taxed at accumulated earnings. You're taxed on distributions, so it's not a simple pass-through taxation. But like I said, you can have an S corp election. No self-employment taxes on shareholder dividends. You have to pay a reasonable salary, to the shareholder employees. For the real estate person in the room, I've seen this kind of interestingly. Strangely, there is also no minimum franchise tax fee, the $800 to the FTD, as long as you're not in business for more than a year. So I see sometimes people use S corps as kind of a transitional corporation because it can just save them a little bit of money. So if you're planning on, creating an entity, for some kind of interim holding or status, I've seen this in 1031 exchanges. Forming an S corp can be helpful and save some money for the client there. Corporations. Not only do you have to file the articles of incorporation with the Secretary of State, and there's some quirks about that. You can designate the number of directors and by the incorporators. But I want to stress this for everybody because I see this all the time. I mean, even just this morning, I had a client, potentially a new client, come to me and say, "Hey, I want to break up a business, that I'm involved in, a corporation, and okay, well, what governs your relationship here, between the board, the shareholders, officers, directors, do you have a buy-sell agreement, do you have bylaws, what kind of resolutions do you have?" "Oh yeah, we filed the bylaws with the Secretary of State." No, you didn't. You don't file those with the Secretary of State. You have to go through these corporate formalities that after you filed your articles of incorporation, you have to have a resolution or a meeting, to adopt bylaws, to elect directors, to issue shares. So I see this all the time, and I strongly encourage you, when we start talking about planning issues, even as an estate planner, business person, real estate person, ask your client to look to make sure they've followed through in these corporate formalities, because a lot of the problems that we're going to talk about later, can be avoided by double checking that they've gone through these issues. I was telling Brandon and Ryan the other day, how do you have a shareholder derivative suit if no shares have been issued? How do you file a complaint saying, like, my client who's a shareholder of this corporation, has a right to distributions and accounting, removal of directors and so forth, when there were no board resolutions, there were no bylaws, there were no election of directors, so everything that's been done, in your corporation for the past 10 years, is all called into question. Who had the authority for it? So these are just issues you can avoid by making sure that all these formalities have been adhered to, in your practice. So double check, just ask. I'm going to go through just a couple of other ones. I love real estate issues. But these are effectively entities, for planning purposes at least. So real property holdings. How do you hold title to real property? These in certain ways are partnerships. And so, first is joint tenancy. I'm glossing over it here, but joint tenancy can actually be much more complicated than you can imagine. And you have to make sure, it's properly formed, going back to law school, basic, real property class. It requires 4 unities to create the joint tenancy: time, title, interest, and possession. The interest has to be acquired at the same time. Document, like a deed, shows that it's vesting as joint tenancy. You have to have equal ownership. Can't tell you the number of times I've seen a deed say, this person has 60%, this person has 40% as joint tenants. Can't do that. You tell me, is that joint tenancy at that point? No, it's tenancy in common. You've defeated the point of the joint tenancy. You haven't established 4 unities if you've done that. And possession, the right to possess the property. Any party can sever joint tenancy. I put this last kind of line in here, joint tenancy with trustee of a living trust. Like I said, the joint tenancy can be somewhat complicated, and even after passage of Prop 19 more recently, I would caution people about trying to put a joint tenant, or putting a trustee of a trust as a joint tenant, primarily for practical reasons, for you planners out there. I have received calls from, the assessor's office, various assessor's offices in different cases I've had where they do not like people taking title as a joint tenant, a trustee of a trust as a joint tenant. They will automatically consider it for property tax purposes as tenancy in common. This kind of makes sense because a trustee, if they're substituted out, even the trustee dies, even if the beneficiary of the settlor of a trust dies, someone just steps in to fill in their shoes. So effectively, the trust is not dying, and there's no survivorship element. So from the assessor's standpoint, and I've even seen this on different assessors' websites, they don't like it. They think it's prohibited, even though that's not what the civil code says. So rather than getting into kind of a bind or a strange argument with an assessor's office about whether or not a trustee can be a joint tenant, it's just an issue you want to dodge. It's kind of a waste of time to have that argument with them. So I caution you against doing that. Any thoughts on that? Agreed.
All this say, for any of us who deal with title companies, let's just take a mission on to educate them to stop vesting title for our spouses in joint tenancy, unless that's what they actually want. Drives me crazy.
Okay, and then the other form, very common, tenancy in common. This is the default form of real property ownership. Effectively, it's a joint venture. It is a partnership. You can designate different percentages of ownership on the deed. You can also designate managers through agreement. And I think the default is to have proportionate allocations of income and liabilities. Have you ever seen a situation where you kind of reallocate it? I mean, LLC, yeah.
I drafted a TIC agreement where we had some different allocations. It doesn't on agreement.
On agreement, yeah. So if you have people taking titles, TIC, I mean, you have a lot of considerations about whether or not you want to have a written TIC agreement. You know, what happens if one person dies, especially here in California now after Prop 19 passed. You know, do you know, who's taking on the liability of the increased property taxes after the reassessment? Is there a right to partition? Do you want anybody to waive the right to partition? These guys are going to talk about buy-sell agreements, but it's really the same idea, you know, talking about valuation of property interests, buyouts, you know, whether or not you can go forward. Is there a process for resolving this co-ownership interest? So these are just, you know, issues. I would also say that if you really wanted to do, you know, take it to the next level when you're creating a TIC agreement, you also agree to file section IRC section 761 election. Just to be clear that, you know, there's a first and final tax return being filed that isn't reporting everything. Everybody is reporting their own income and liabilities on their own tax return. You don't have to file partnership tax returns for this co-ownership interest ever again. So I would recommend that for everyone. With that, I'm going to turn it over to Brandon. He can start getting into the really complicated planning issues.
Yeah, well, thank you, Michael. I appreciate the introduction. I appreciate the opportunity to be here. And I think that the refresher was certainly helpful, especially as we move forward. I will apologize in advance. For one, speaking into a microphone is completely unfamiliar to me, so I will do my best not to drift in and out. And two, my voice has been taken from me by my children. So I will do my best to keep my voice so that you can hear me. But if I do drift off, please just let me know. One other note I'll make is that I'm going to go over a lot of stuff, or try to, and I don't expect people to be paid that astute attention, but if you really do want to have notes about this, I'm happy to send this to you so that you can just listen and you can have this kind of as a reference guide moving forward.
I encourage you to reach out to him with questions. Because I'm just saying, as we were talking about this and he gave me the outline, there's a lot of stuff in there that I've never even seen before, and I've been doing this for a while.
So the way I approach this class or course is kind of like your clients. You're a client that comes to an estate planning attorney and you own a business and you want counsel. You want counsel not just as an estate planner, but also as a business owner. And so the way that I have approached this is to first identify the issues and then provide some recommendations. And so I'll start with probably the most obvious issue for a prospective client, which of course is probate. You want to establish your estate plan to avoid probate. And a lot of clients have some idea what that means, but I don't think most of them really appreciate what that means. They think it's a hassle, they've heard it's bad, but what does that mean specifically? And for the non-planners in the room, of course, they're aware of it, but maybe they don't know all the intricacies. And a couple of the things that I want to highlight why probate is an issue and why you want to avoid it at all costs is one, the cost. It is incredibly expensive. As I tell clients all the time, you know, if you think lawyers are expensive, selling estate plans is bad for business. Probate is great. The statutory fees are very high and very costly. Currently, if you just have a $1 million gross estate, not net estate, but gross of all liabilities, the attorney's fees statutorily are $23,000. You add that in if your personal representative is going to claim the fee, which oftentimes they don't, but they're entitled to it, they're going to get another $23,000. And then you add in the court costs. It can be very costly. It'd be much easier just to actually establish your own estate plan. Another reason why probate is really a pain and should be avoided is the delay. It is a lengthy process. No matter how proficient and how simple the estate is, it is going to be lengthy in the state of California, and that is a promise. Some clients are misled by the fact that yes, they have to have an initial hearing date pretty immediately, but that doesn't mean that they have to have a hearing date to conclude the probate immediately. And so I would say, you know, certainly during the time of COVID, it was on average at least 18 months from start to finish. It may have calmed down a little bit now, but there's really no chance of it being less than a year. And I would explain to my client that even if they never want to see an attorney and they don't want to participate in this estate planning process, the delay and the cost, frustration of a probate alone should incentivize them.
As an example, I just filed a petition for final distribution in Alameda County this week, March. I got mid-March for a hearing date. So just for you people that don't do probate, just realize it takes, each hearing per motion could be set out 6 months or more.
Another thing that is not mentioned and may not be a huge deal for a lot of people, but can be for other clients, is that a probate is public. It's a public hearing, it's public filings, and so you may have business owners or clients who do not want to be advertising their business to the world. And yes, I acknowledge that not everybody is checking the newspaper to see what the next probate hearing is, or pulling documents at the local courthouse, but just understand that they can. And that for some clients is enough reason to establish their estate plan. So another reason I would also advise clients to obviously talk to an estate planning attorney about this is that it's going to have that conversation and open up that dialogue of issues that are unsettled. So one thing that can happen with clients who do not properly plan, who are business owners, who do not properly plan their estate plan, is that they can have conflicts with their business partners. And the conflicts can arise in several different ways. One issue is you can have valuation issues, of course, as it relates to the business. If you do not have a process in place for evaluating the decedent's interest in the business, that can cause additional delay in the administration. That can cause additional frustration. It can lead to litigations. I'm sure Michael and Ryan have encountered that at some point. But it can also raise other questions, like who's eligible to succeed to the business interest? And instead of leaving those for chance, having that conversation now with your clients can be valuable. It can be valuable because you can help you work through a lot of practical issues. Another thing that I find beneficial about having these conversations with clients is addressing the managerial issues that your company or business may have with your client. For many of our clients, they are the key person of their business. And they haven't thought past what happens if I'm incapacitated or if I pass away, who's going to take over the management of this company. They have some ideas, but that's what they are. They're just ideas. They haven't flushed them out. And I think that having this conversation with your clients to really work through the details of that is beneficial. It helps clients. I just had a client this past week that has a thriving business, but he's the key person of it, and You know, when I was talking to him about his business succession plan and what he hopes to happen with the business, his concentration was mostly on caring for his surviving spouse who has nothing to do with the business. And that's a fair question. But if the business isn't thriving and operating, there's going to be issues providing for the surviving spouse. And so we had to have that conversation of, well, do you have key person insurance? What is your liquidity? How are we going to bridge this transition from you as the key person managing this operation to even a sale, to facilitate this company, to keep it afloat, even to the process to a sale to a third party, if you have no partners. And so those are the types of conversations that you have when you get into the estate planning. The other thing that I would say that goes unnoticed oftentimes or overlooked is the knowledge. I keep saying key person, but a lot of times, a lot of our clients are the person that started the business or keep it running and maintaining it. They have institutional knowledge, and that institutional knowledge is not just valuable from the standpoint of, yes, I know how to make this widget and I know the most efficient way about it, but it also instills confidence in the customers. So the clients of the business, which you have to be considering. The idea is to have a viable business, or at least have a viable business to be carried out through a sale when the decedent passes away. And in this instance, have you had those conversations? Have you transitioned that institutional knowledge down so that the company can continue to function at least as it transitions? Other reasons why you want to engage in estate planning, especially as a business owner, are the liquidity issues that might arise. And in this instance, one of the liquidity issues that we have with business owners oftentimes is the estate tax. And I understand that right now the estate tax credit is relatively high. It's roughly 13 million per individual, 26 per married couple. But that is scheduled to sunset January 1, 2026. And at that time, it will roughly be about 6.5 million per individual, per married couple. And for a lot of our clients who do have successful businesses, that starts to get close to an estate tax liability. And the question that you have at that point is, how are you going to pay for that estate tax liability? Because the IRS doesn't really care that you haven't planned. They care about getting paid. And even if you can extend your estate tax return, you still have a debt that is due 9 months after the date of death. You do not get an extension for that unless you fall into some very limited circumstances. And so for some clients, you need to have this conversation with, you've built this company, you intend to pass it down, but if you have an estate tax liability, you may be forced or confronted with the issue of liquidating. And again, and Ryan I know knows a lot about this, there are some alternatives in the estate planning world. They're not great.
Especially with interest rates right now.
Yeah, they're not great. Make no mistake, the IRS is not your friend. They will do some things to help, but they still want their money. And even when you do some of these alternate avenues, they come with their limitations. And I think the most popular one, and I know Ryan can speak to this as well, is a 6166 election under the Internal Revenue Code section 6166, which allows you to defer an estate tax liability, but it has limitations. First of all, it's not the entire estate tax liability, it's only the portion associated with the business. So you have to make that calculation, and you have to say that if 3/4 of the estate tax liability is due to the business, then 3/4 of the estate tax liability can be deferred, but the other quarter is due immediately. So it's not a magic bullet at the beginning. You still have to have liquidity in the estate to at least pay some of it. The other thing about a 6166 election is that you have 14 years, roughly almost 15 years, but 14 years, 9 months to pay off the payments. You have 5 years of interest only, and the balance you can make equal installment payments. But as Ryan was saying, the interest rates are getting higher and they're not deductible. And so you still have to pay off this note. And the IRS will put a lien on your assets until this liability is paid off. Not only that, they will continue to monitor this deferral by sending you annual notices asking you whether any of the business interest has been transferred, any of the substantial assets have been liquidated, and you have to attest to the fact that the business basically has remained unchanged during this period. Because if you do not, or you do have substantial changes, then you have triggered an acceleration and no longer can defer your estate tax payment. And the reason this is particularly important is because we know that we have multiple beneficiaries. So we understand that we want to do an estate tax deferral. Everyone at first is all in favor of that, thinks it's a great idea, until they find out that they cannot alienate their interest. The company has handcuffs, essentially, because if they do not participate by the rules of the IRS, the estate tax will be due immediately. And so when you have beneficiaries who don't see eye to eye on the management of the business or who should be part of the business, you now have conflict not only with your co-owners, but your IRS is effectively a co-owner that you must appease. So it's something to keep in mind. And to a lesser degree too, if you have a business owner that has substantial assets in there, you have to evaluate the fact that some of these assets may be encumbered and review some of the loan documents related to that. I've had clients that unknowingly or unwittingly have actually personally guaranteed loans on assets. Now, obviously not a great idea, but not all clients are terribly sophisticated. They may be very good at what they do and be very successful, but they don't think about all of these entity issues that Michael was talking about. Nobody's educated them on that. And so this is pretty much the first time that they've even been confronted with it. And so you can go back to them and say, I don't know, Bob, but you have a personal guarantee on this loan. And if you die, there's a possibility they may accelerate this, which is now going to create another liquidity issue to be aware of. So having these conversations is important, because I cannot tell you how many times, I know Ryan has encountered this, where you have a grieving decedent, a grieving surviving spouse, and you're basically already right up against the clock. A couple of other things that I would like to just lay out as far as we're just kind of identifying some potential issues with a prospective client is there's consequential tax elections. And I know that Ryan and I are tax lawyers, and we probably could talk about tax until we're blue in the face. But I promise I won't beat a dead horse here. But there are really costly tax elections that need to be considered. And they get back to actually what Michael was talking about in the outset about, choice of entity. And so these consequences are not something that should just be debated and thought about today, but or at death, but they should be thought about today, because you may need to do a reorg. You may need to do some type of shifting of assets, because you may have set your heirs up or your beneficiaries up for disaster moving forward. And so a couple of those tax elections that will be hugely consequential begin with partnership. So you have a 754 election that is available. And as Michael was talking about, most LLCs, and Ryan was mentioning this as well, most companies today, at least from an estate planner standpoint, are formed in the LLC. And there's so many reasons for that. But one of them is the 754 election. An LLC can be taxed as a partnership. And as a partnership, you can make an election for 754. And what that means, without getting too down in the weeds, is that a partnership has an inside and outside basis. There's the partner's basis in the ownership interest, meaning their member interest, and then of course there's the actual partnership's basis in the underlying assets. And this is consequential because if you have a decedent who passes away, Well, we all understand, or have probably heard from a friend of a friend, that when you die, you get a new basis on assets. Well, the way it works with a partnership is that the outside basis, meaning the decedent's ownership in the partnership, that gets a new basis. But in addition to that, there's an opportunity for the underlying assets of the partnership to get an adjusted basis. Now, that adjustment is limited to the decedent's interest in the partnership, but it is something to keep in mind. Because if, for example, and I've actually recently come across this, unfortunately, we have a decedent who owned real estate in a corporation. That real estate is not going to get a new basis. It's not going to get a new basis because corporations don't have 754 elections. Now the stock will. So these are the types of things that you want to identify with your client when they come in. You sit down and you look at it and you say, oh, I see that you're operating rental properties out of a C Corp or an S Corp. You know, that's less than ideal.
It's not good.
Can I just add to that? I mean, and you can't distribute it out either. You'll get income. You'll have to pay income tax on the distribution for all the capital gain. So
I've had clients want to reorg into an S corp from an LLC for some reason. I'm like, well, what, you have real estate in there, which means that real estate's going to be stuck in there. If you ever want to get it out, it's going to be taxed.
Mhm.
If it stays in LLC, we can get it out without tax.
Yeah.
That's again, LLCs are great for real estate.
So you know, mom owns a corporation. She has property in it. I mean, effectively, you have to wait until mom dies.
Yeah. You have, so the entity conversation is critical, and even though we're estate planners and we don't pretend to be business owners or you know, like my colleagues over here who handle all the corporate side at my firm, you have to work with a team of people who actually know the ins and outs of these entities, because they can be hugely consequential. The last thing too that I would say from the problem side, although there are many more issues, but the last thing I would like to note, of course, is property taxes, especially following Prop 19. And for business owners, Prop 19 is consequential. It's not as consequential as it was for residential property, but you have to alert your clients to the reassessment issues or the potential reassessment issues. And you have to be very clear about the history of these properties, how they got into their entity, were they purchased by the entity, were they transferred in? What's the history of the entity ownership? Have there been multiple members? Have we transferred membership owners? Member interest? Have we sold them? Have we gifted them? Excuse me. So you have to be aware of that, because reassessment is a big problem. It creates another liquidity issue. It creates a viability issue for the company.
Since we put this presentation together, I actually had a circumstance where client's mother passed away in 2019. Entity ownership, this was an entity ownership, and we reported to the BOE the change of ownership. He just got the estate tax bill 3 years later. So this can also, this goes into the delay, you know, issue. For, you know, the assessor's office, the BOE, the assessor's office finally, you know, got everything together to send out that estate tax bill 3 years later. So there's, I mean, this,
Yeah.
you have to plan for it, and you have to understand that it's going to happen at some point.
And you know, related to the property tax, and I want to move on to other issues, but one other thing that is unique that we're facing now is as properties continue to go up in value, and we understand big picture where these entities are going to end up, whether it's to another owner or whether it's to a beneficiary of an estate, you may want to consider triggering the reassessment today, which sounds crazy, but in some instances, it could be actually more cost beneficial, and there are creative ways to do that. My colleague Ali over here and I actually just worked on a really interesting way to do it, to actually lock in the property taxes moving forward, intentionally triggering it today, but ensuring in perpetuity that the property tax basis will remain despite the passing of beneficiaries. So those are conversations you want to have, those are issues you want to identify. Now, moving on to the recommendations that I would have for a lot of clients, now that we've identified what are some of the problems, I mean, the most obvious recommendation, of course, is to establish your estate plan. Put your assets in a trust. Have a durable power of attorney. Avoid conservatorship. Avoid probate. That's really the most easy, obvious solution at a minimum to do. And of course, make sure you fund your trust. Yeah.
That means deeds.
It means deeds, it means assignments, it means canceling and reissuing stock, it means all of that fun stuff. The stuff that quite candidly bores the hell out of me, but I get Allie to help me with. Yeah.
Sorry, I sent plenty of things your way as well. I can't.
Exactly.
Many things are over my head too.
Exactly. So that's the most obvious solution. The next obvious solution is speak to your clients about having a buy-sell agreement in place. I know Michael was just mentioning this earlier. Ryan and I were talking before with clients that just don't even have buy-sell agreements. They get into business with a partner and life is great. And life actually may be great between your partners until one of them passes away. Now you're a partner or co-owner with their children. And so how are we going to manage this? And so you want to have a buy-sell agreement. And I'm not going to pretend to be the expert on buy-sell agreements. I don't draft. But a few things that I understand that are important to set out in them is obviously a process for setting the value of the business interest, developing a strategy for those tax elections that I was talking about. Are we going to make a 754 election? Should we reorganize now? Things of that nature. And then another thing that I think is helpful with a buy-sell agreement, it comes up from time to time when I'm speaking with clients, is just illustrating that you have thought about these issues to your clients, to your customers. So you don't have to obviously give them your buy-sell agreement, but at least, when they do ask, and it does happen with some of our clients, they get older and people ask, who's next in line? And so you can say that I've had these conversations, I know that I'm educated on these issues, and I think that instills a lot of confidence in your business from outside parties. Another thing to have, if you have, with your buy-sell agreement, of course, would be an operating agreement, and in that you can have a process for succession of management. How are we going to elect managers? Who's going to be in charge of that? Same with corporations and bylaws. So you want to make sure that you have that. One other issue that I would say that is helpful when you're having these conversations is identifying and anticipating family conflict. And I think that I cannot emphasize that enough, because you as an estate planner, as counsel, have to ask the difficult questions and have to confront those honest conversations where you have to make decisions. And I think you need to be very candid with your clients about if the business is co-owned or if it passes down to these other owners, understand, to your beneficiaries, understand that they're going to have rights, certain interests, and those rights and interests can really impact your business. And so it doesn't make sense to give your business interest to all of your kids, or does it make more sense to give the business to one kid and offset that with a different distribution to another kid? So I think that is something that I see more and more, and I've actually seen it work in a positive way more and more.
I totally agree with that. I just want to make one comment on that is, the clients are thinking about what it is today, what their business is today, but we know we're planning for the future. What is that business going to actually be worth when they actually die, when mom and dad both die in the future, 20, 30, 40 years in the future? They say, oh, it's only a $5 million business now. Well, what happens if it's 20? Because as these numbers go up, conflict goes up too, we all know that. So just, that's what I try to paint a picture of these clients as well, is like, think about those big numbers. Yeah, they seem pie in the sky, but it can happen. It can happen fast.
Yeah, thank you, Ryan, I agree. And so now moving on, because I am trying to cover a lot of information, and I apologize for kind of teaching it like a class, but the next issue I would like to address, as we were talking about, were the liquidity issues. Again, those are the type of things that can sink a business. And in this instance, I'll start with your estate tax liability. If you anticipate an estate tax liability, whether it's at 13 million or 6 million, which I feel very, very confident that it's going to get reduced to 6 million.
For sure. Think Congress is going to do something?
It would have, in order for it to be extended, you would have to have a Congress, a House, a Senate, a House, and the President extended.
Yeah.
I don't think they can agree on the day of the week, so if they don't agree on anything, which we can pretty much anticipate.
That said, you can't really predict political climate, so
Yeah.
nobody knows. But you have to plan for it.
Yeah, it only took 3 weeks for Speaker of the House. Reducing the estate tax, how can we do that? There's a few ways to do it. One is the possible estate freezes that I promised to teach Michael about. So estate freezes is basically locking in the value of the estate today for estate tax purposes. And so there are several ways to do this. I know that Ryan and I do a lot of this planning, but these techniques would include GRATs, QPERTs, intentionally defective grantor trust, or intentional trust, I don't know how you call them.
Yeah. I've just never heard it called an estate freeze.
Yeah, so they're an estate freeze, and basically what you're doing is you're removing the asset today from your estate at the current value, and you're moving it into some form of irrevocable trust where the asset will hopefully continue to appreciate, but it appreciates outside of your estate. So the value and the cost to your estate is effectively frozen. And so you pay gift tax today, or you may not, depending if you do a sale. But for most clients, and especially in today's climate where the credit is so high, we're advising clients to actually use their credit, not effectuate a sale, and just take advantage of the credit while it's very high. One thing I would tell you on the flip side of that is that when you do transfer these assets out of your estate, the government's going to look to make sure you've given up control of those assets. And for a lot of clients, that's difficult. That's very difficult. And so, how do you advise a client about doing something like that? Well, you try to create parameters where the new owners or the beneficiaries of these assets have some limitations. But I will acknowledge to you that recently the IRS has gotten much more aggressive about this. And one of the ways that they've become very aggressive, and Ryan knows this, is with LLCs. It's very common for family limited partnerships, LLCs, to be transferred to irrevocable trust. And the reason why, and Ryan was alluding to this earlier, that LLCs are really helpful is because of the management structure. Mom or dad can gift their interest in the LLC and still be the managers of the LLC. So they're giving up a right to income, a right to distributions, but they're not giving up the right to manage. And that was a lot more popular a few years ago, and I would say to the unsavvy estate planner, it is still very prevalent. But there is a case called the Estate of Powell that all estate planners need to be very wary of. And the reason you need to be wary of it is because the IRS was successful in this matter and continues to stack victories on this matter. For the longest time, the Supreme Court held that when a family member gives up a business interest to an irrevocable trust, whether they're the trustee of that trust or not, but that trust is, to their son, their daughter, their best friend, whomever. The IRS held that, yeah, mom and dad might still be the manager or still be the director of the company and may effectively have control over this company in that capacity. That control doesn't constitute estate tax inclusion, and therefore this planning technique is very valuable because when they operate as the manager or the director of that company, they do it in a fiduciary capacity. So even though they may want to do whatever they willy-nilly want, they can't because there's fiduciary laws that prohibit them from doing so. And what the Estate of Powell says, or starts to say, effectively, is that's a bunch of BS. That fiduciary relationship isn't really true. And mom and dad do control the company. And so, it's not great. And the IRS, with that victory, has gotten more and more aggressive. And we have to caution clients that these opportunities for estate tax freeze are still very much alive and well. We just have to do them the right way. We cannot be as greedy as we once were about retaining control of the company. So there are ways to reduce your estate tax through estate freezes. There are also ways to do it. When you make these types of gifts today or transfers today, you get valuation discounts. I'm sure most of you have heard that. You form an entity, you slice it up into several pieces, and then you get a minority interest discount or lack of marketability discount. So those will help you utilize your estate tax credit by maximizing it. It's pretty common, I'll ask Brian, but it's pretty common for you to get a lack of control, lack of marketability discount for a minority interest in a business around 35%. You probably don't want to go over 40% is the rule.
That's too greedy. I don't do any above 40.
Yeah, so over 40 you start to get a little bit out of hand.
And if you get audited, the IRS will just say 15.
Yeah, prove otherwise.
Yeah.
Prove otherwise. So when we're talking about, addressing liquidity issues, obviously we want to reduce the liability of the decedent. So we want to reduce the estate tax liability, and one way to do it is to do these estate freeze techniques. Another thing that you want to consider when you're talking about liquidity issues, and we mentioned this a moment ago, is life insurance. I'm not here to sell anybody life insurance. I'm not an expert in life insurance. I'm not even necessarily the biggest fan of life insurance necessarily, but I will tell you that life insurance can have a lot of value in the right circumstance, whether it's key person insurance or an ILIT, irrevocable life insurance trust, to create immediate liquidity. Because if you recall, I said that you may be able to defer some of your estate tax, but you're not going to be able to defer it all. And you are going to have a necessity for liquidity in the outset. And I will tell you this, more as a practical matter, when dad is dead, beneficiaries come with their hands out looking for money. And when you're the trustee and you say, well, I know dad has millions in his bank account, unfortunately, we've got to hold on to that for a little while. First of all, we've got to pay the IRS, and second of all, we have some other liquidity issues. They're not terribly pleased with you. So you want to make sure that you have addressed this liquidity issue, and life insurance may be a good part of that. The last thing that I would mention and then I promise I will allow Ryan to speak, is that you want to really give interest and you want to give heavy consideration to your choice of entity. That's why we started with it, and I will end with it, because your choice of entity is critical to the opportunities you have as an estate planner. You know, from a C Corp, we talk a lot of junk about it. I'm not a huge fan of it, but if you're the right type of C Corp, you're in the tech industry, you're in the wholesale industry, you manufacture something, it might be great. You could do a QSBS, you know, a qualified small business stock, which could be hugely beneficial with non-grantor trust. You could exclude significant capital gains when that stock is sold, so that could be a huge benefit. If you're a partnership, as we were mentioning, the 754 election, 1031 opportunities, and then of course if you're an S corporation, there are benefits to being an S corporation, but one of the downsides to being an S corporation is it's not great for irrevocable trust. Irrevocable trust cannot be shareholders of an S corporation unless they are a grantor trust, a QSIT, or an SBIT. And I will tell you, what, 90% of estate planners miss this?
Yeah.
And
Because they assume it's a grantor trust.
yeah, they assume it's a grantor trust, or they've never even thought about this issue, and it will blow the S election for that company after the business owner has passed away. So I will let Ryan now kind of go over some more hypotheticals, and then of course if you have any questions, I'll be happy to answer them along with
You
it.
know it all, mostly, so I just want to make one, you know, we're here to give you some tools. So property taxes are just a topic that just pops up a lot, especially since Prop 19 passed. I have heard, I think there's going to be 2 ballot initiatives on this coming up, looks like. One of them is a complete reversal of the parent-child component, and the other one was just like bump up that 1 million number up to like 1.5 or something. Anyways, when it comes to legal entities, there's a whole different set of rules that Brandon was talking about. Go to the BOE website, it's actually a pretty good website, and there's a whole page on the legal entity ownership program, because there are 2 rules that people need to know about this. And it happens a lot, it's obviously real estate, moving through legal entities, and how much we can start transferring to other partners, other business owners, or the next generation. So I would just say go to that website, because there's 2 rules you gotta look at. One of them most everybody knows, which is the change of control rule, but there's the original co-ownership rule. That's the one that catches some people off guard. So we can move on to that.
And you have to do these things far in advance. I mean, this is not deathbed planning. I mean, when you're transferring, you know, mom's property into an LLC, so you can, you know, transfer proportionate, you know, some smaller minority interest to the kids. It doesn't trigger a reassessment, but then, you know, you want to drop it out of the LLC and then put it in another, you know, back and forth, so that you can work around Prop 19. Hopefully, you don't get, you know, tagged by the assessor for the step transaction document. I mean, so, you know, I don't know if anybody went to I think there was an EPTEL presentation by Fong Hua, the assessor of Alameda County, and he said that there were some planners that he saw them, you know, within a matter of like 1 or 2 days, you know, record a series of deeds, you know, just like, you know, deed into the LLC and then deed out of the LLC. Yeah, exactly. It was like, I can't ignore this. You know, I mean, like, I see what you're doing, so like, take it easy, people. You know,
Say season it.
yeah, season it. You know, like over, you know, 6 months, a year, you know, multiple years.
Different calendar years.
Have a good reason, you know, for putting it in or out of an LLC. Like, you are creating a narrative. You're creating a story as to why you're basically working around the reassessment rules. So, you know, this is not something you do, you know, when mom's about to die. Like, you need to think ahead, you know, way ahead. And Prop 19 is prompting those conversations, I think, more and more.
For sure. And one other point I make is, when it comes to valuation, like we talk about buy-sells, operating agreements, partnership agreements, you're going to have those provisions, hopefully, because you're listening to Michael here, about valuation. How we, you know, let's say we have two partners, two business owners, and they agree on a valuation formula. They're like, yeah, this works for us, but it's not really for them. What if you're the one that dies? Your client's the one that dies. It's their family. It's their trustee, their trust fund, the ones that are trying to enact this. And if the formula is unclear, you're just going to litigation probably. There's a lot of litigation or valuation disputes. So it's just, again, trying to get in the client's mind and say, put yourself in this situation in the future. You're the one that's passed away. It's your family now stepping into this role, trying to get the liquidity out through a buy-sell. Buy-sells aren't the be-all, end-all. They have to be well-written, of course.
The final thing that is pertinent to all of us and to other professions and other industries is that you have licensing. You can't just pass on the widget factory to your son or your daughter. You may have a law practice, you may have an architect practice, you may have, a liquor license, you may have things that require additional planning in advance and have limitations. And so, what I would like to illustrate to you is that while we like to think of ourselves as patient people, and maybe our clients might be patients, oftentimes the beneficiaries are not. And so you have to work through these issues, and they're not up to you, the timing of them. And so you want to think about this in advance. Who's the right person to facilitate this and expedite this? Because you probably are going to have anxious beneficiaries waiting to move forward. And that's just an unpleasant position to be in for yourself and also for your client, who's probably going to be the trustee.
Typos. Let's talk typos. We have about 10 minutes left. Let's see. I have 3, in increasing complexity. Let's see if we can get through the first one, maybe the second one. And this is just to, again, introduce you, if you practice probate, you can understand what can happen on the business side. If you practice business or real estate, you can understand what's happening on the probate side. So, scenario 1, commercial property purchase, income property by 3 people. There's a purchase money loan, and it's in the name of the 3 owners. And then they go to their accountant. The accountant says, hey, I think you should form an LLC. There's some benefits there for ownership. I'd like you to do that. But they don't need it to the LLC. Oops. But they do have an operating agreement. It doesn't have buyout provisions. And then one member with a pending divorce of a second marriage, no kids, dies without a will. The deceased owner's daughter contacts you. What do you do? Issues? Will you guys? Yeah.
Very many.
Okay. Well, I'll just go to the next slide. We can kind of do the reveal. It's probably easier to talk through it. You have an owner without a will. I mean, somebody has to establish authority over that deceased member or property owner's interest. And so you're going to have to do a probate. So for business and probate people, you can't just say, hey, I'm the surviving spouse. I run the show. Give me my money. I want to buy it. No, you have to establish authority. And step in the shoes of the decedent. So you're definitely looking at probate, appointment of an administrator. If there's some kind of urgency, you can do a special administration. That's a temporary administration. You can get an expedited time frame.
Good luck.
Yeah. Yeah. But I mean, you have, this brings up the issue of the kind of second marriage and the daughter from the prior marriage. I mean, there's a natural, unless they're, well-functioning family, I could expect there to be some potential conflict there. Who runs the show, who controls it, who has rights to the property.
Maybe the daughter files for probate and the wife files a property petition.
Yeah, or the wife comes in and says, hey, I have priority to be administrator here, thanks for all your work, but,
Or you
I'm
don't,
in charge.
or you don't have a surviving spouse and you have surviving children competing petitions for being in charge. So,
Right.
lots of delay.
Right. All the fun.
Yeah.
Not for the other two business owners.
Yeah, not for the business owners. And with the operating agreement, I mean, perhaps there is some provision for member dissociation. I mean, this goes kind of back to some of the things we were talking about before. Without a buy-sell agreement, there's nothing in the code that mandates a buyout. There's no, you just become, by the corporation code, you become a dissociated member, by reason of death, bankruptcy, incapacity, things like that. So you have a right to distributions, but you don't necessarily have a right to, manage or have them give you money to disappear and be bought out. So you're kind of stuck. So maybe there's something in the operating agreement that gives you, more rights than just a, simply dissociated member. You have to take a look at that. Other issues, I note here on the slide, bank might accelerate the loan. You might have a time pressure issue to resolve some of these things. A lot of commercial lending agreements have, credit agreement mandating certain ownership by people that provide guarantees. Maybe there are credit requirements. Maybe you have to show you have money in the bank. But there might be a technical default because one of the members is now deceased and you can't prove up that credit requirement. So you have a loan issue. You have a property tax reassessment issue. And this one's a little bit of a twist because, there's a TIC ownership on title, on record title for the property with the recorder's office, and that's what the assessor knows too. And so the proportionate interest in the property upon death, in theory, is getting reassessed. Not the whole property, but let's say it was a third, but that third of interest in the property is theoretically getting reassessed. Now, for your real estate people and your business people, I mean, there are probate tools that you might want to employ to solve this problem, to try to avoid this problem. In the probate code, there's section 850, which
I expect it to.
that to have it be confirmed as an asset of the trust. But I would actually consider, as the LLC, the LLC was formed, everybody was promising to make initial contributions to property into the LLC, you might be able to file basically an expedited quiet title petition, if you will, in the probate court, saying, hey, that third interest in the property owned by that deceased, that should be an asset of the LLC. That dead person promised to put that title to that property into the LLC. So we want you to issue an order confirming that it's either a property, an LLC property, that third interest, or have it transferred, to us by the administrator. And I don't know if this, honestly, I don't know if this would work. I've never encountered this situation, but you might have a colorable argument with the assessor's office to say, hey, even though it was titled, a certain way, look, we have a court order saying that this is LLC property. Maybe the other partner, the other members have given their interest into the LLC, and at that point, you're only notifying the BOE and the assessor's office of the third change in ownership of the LLC, not the property. So you might be able to avoid the reassessment issue.
The one thing I could anticipate as an issue that a judge may not be thrilled about is that, remember, you're in probate, and so you do have a creditor's process, at least for unsecured creditors. And depending on this decedent's status of removing this asset from a probate where the unsecured creditors haven't had their time to make their claims is probably going to be something that a judge is going to be hesitant about, especially something that is as valuable as that. So you better be persuasive.
Well, that's the whole point of our talk today is, do we really want probate court involved in this at all? Maybe there's a different suit going on, a civil court. We were talking about this. Which court is it going to end up in? Is a civil side going to try to kick to the probate side?
Yes.
Yeah.
Probably, right? Depends on what the issues are. I think.
Unless that white tip of the one case.
It just becomes a mess.
Yeah. I mean, you might get, competing lawsuits. I mean, probate code, 853, says that, if there's already a pending civil suit, on the same claim, same issue, the probate court has to abate, just wait until the civil court makes their decision, and likewise. So whoever's filing, so there's almost a race to see where you can get it. But I mean, in theory, like the civil court is the place that's going to determine, let's say, there are distribution issues, accounting issues, control issues, things like that. Probate court isn't going to want to get into that. I mean, that's not the jurisdiction of the probate. The probate court wants to look at, the asset of the estate, The LLC as a whole is not an asset of the estate. The control, the accounting functions, that's not within their jurisdiction. So civil. You might even have, as I put in the slide, you might even have a complaint for involuntary dissolution. In the alternative, let's say the property doesn't get placed into the LLC as part of this whole process. Well, and you're looking at a partition. So you plead in the alternative. It's 3:30 now. We're on hypo 2. I don't know if we have enough time to run through this, honestly. Does anyone? Yeah, Matt's giving me a look.
Any pressing questions?
Yeah, I think questions. Why don't we go with questions? Yeah,
You can go, Matt. It's okay.
yeah. Do I have any hard questions from the cave that I was coming to expect?
What's the difference between the Gragan loan and is it the 66 one?
The Gragan loan?
Yeah.
What's your question about?
Versus the 66.
What's the difference?
Yeah.
A Gragan loan is very complicated. The issues with Gragan loans, and I'm glad you asked, it's actually in my outline. I skipped over it because they told me it was too boring. A Gragan loan is an opportunity to pay off the estate tax by taking a loan essentially from a third party. Oftentimes in this instance, it would be from the company that is actually the family business. So you can do that. The Gragan loan is based off the Gragan case, and there are limitations to it. You have to actually charge a true interest rate on it, so the interest rate will likely be higher than what the IRS is charging you. But the benefit of a Gragan loan is that the actual interest rate is deductible on the estate tax return. So those are things you have to think about. What is the difference between the two? The 6166 is a codified election in the Internal Revenue Code, so you know what you're doing, you know what you're getting into. A Gragan loan is an opportunity to be audited.
How many years do you get for to pay on the 6166?
You have basically 15 years.
Yeah. That's a lot.
Yeah, 14 years and 9 months.
Can't the Gragan just be AFR? Or does it have to be market?
No, it has to be market.
IRS will give you one.
Yeah.
Even those are higher now.
Yeah.
So you guys said the exemption is going to drop from 12.9 to 6.5. So if you make a gift now of $6 million,
Yeah.
after that goes down to about $6.5 million exemption for gifting?
No, so it's a very good question. So right now you have 13 million, we'll call it, okay? So you have 13 million. If you run through your 13 million all the way up until January 1, 2026, you gift it all away, then on January 1, 2026, your credit amount is 0, okay? And so the other thing though, the benefit and the reason why clients are gifting now is the government says they will not claw back the additional amount you use. So you're 7 million over, right? On January 1, you had 6 million, but you've spent 13 million, so the delta is 7 million there. that 7 million is on the house. The IRS is not gonna claw that back. You're free and clear. If you, the natural next question is, if you give 3 million today, let's say 2 million, because the numbers will get weird. If you give 2 million today, then on January 1, 2026, your credit's not 6 million, it's 4 million.
So if you gifted 7, you're gonna have 0.
Yep. So the name of the game is somewhere, if your client can afford it, is somewhere between 6 and 13.
Or maybe use the exemption of one spouse and leave the other spouse intact. So look, it's a mitigation strategy. If you don't have enough assets to gift,
It's a great idea.
that's where we get into separate property, community properties, transportation agreements.
More questions? Does anybody want to stay for the hypo?
Awesome. Thank you.
It's more of the same.